Well, there are both state and federal laws that protect employees from being discriminated against because of their membership in a protected class. These statutes also protect employees from being retaliated against because they've engaged in legally protected activity. Well, what does that mean? Well, there are state and federal laws that make it illegal for an employer to discriminate against, treat differently, terminate an employee because of the employee's age, race, creed, color, sex, sexual orientation, gender identity, national origin, religion, or disability. The laws make clear that an employer cannot discriminate against an employee because of the employee's membership in a protected class. The statutes go further than that. They say that it is illegal for an employer to retaliate against an employee because that employee has complained about or opposed illegal discrimination. So you can think of an example in which an employee is being discriminated against, harassed at work because of his race, for example. The employee complains about the racial discrimination. The employer fails to take any corrective action. Instead, the employer retaliates against the employee, making his job more difficult or terminating the employee. That employee may have two potential claims. He may have a claim that he was subjected to illegal discrimination in violation of both state and federal law, but also that he was subjected to illegal retaliation because he had complained about discrimination. Interestingly, the laws protect not only an employee who is standing up for him or herself, they also protect a situation in which a coworker sees illegal discrimination and complains about that discrimination. If that whistleblowing employee is subjected to retaliation, that employee may also have a claim. The aim of these laws is to create a work environment in which employees are not subjected to bad treatment or unequal treatment because of who they are. On top of that, the law also, in certain circumstances, requires some affirmative steps to be taken by an employer. For example, in the situation in which an employee has a disability, as defined by the Iowa Civil Rights Act and the Americans with Disabilities Act, the employer has a duty to have an interactive process with the employee to determine whether or not reasonable accommodation can be made that would allow the employee to do their job. So these laws are expansive, they're complex, they're there to protect employees, and it's important, if you believe that you may have a claim like this or a situation that invokes these statutes, to reach out to an attorney who practices in this area and who can answer any questions that you might have.